The next case to come before the court is Angela Pennington v. Mercy Regional Medical Center et al. Are both of the parties ready to proceed? Are you waiting for anybody else to join you?
We're ready.
We're ready to proceed. Thank you.
Okay, very well. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being recorded, so please stay behind the podium, keep your voices up. You should not use the names of children or minors or victims. Should that be relevant to your argument, you can refer to those folks by initials or generic terms. We have read your briefs, and we're ready to proceed when you are, and I would just ask now, the appellant, would you like to reserve time for rebuttal?
Yes, I would, Your Honor.
Okay, and how much time would you like to reserve?
Is the maximum 5 minutes?
Yes.
I'd like 5 minutes, please. Thank you.
Okay, very well. And when you come to the podium, if you would please introduce yourselves, that would be appreciated too. You may proceed when you are ready.
Good morning, Judge Carr. Good morning, Judge Sutton. And good morning, Judge Stevenson. May it please the court, I'm Thomas Misney, a retired surgeon and trial lawyer who does not have any billboards or 5-second TV commercials. People always ask, so I'd like to address that. So you're not sitting there for 15 minutes wondering, is that the guy? I represent Angela Pennington, a nurse at Mercy Memorial Hospital, who's the appellant. As you know, this is an appeal from the trial court's denial of the plaintiff appellant motion for a new trial under Civil Rule 59, Section 9. In that section, errors of law occurring during the trial can be appealed, and I'm proposing that there were 3 errors of law made during trial that prohibited me from impeaching the defendant pathologist, Dr. Fazi Haq Ali. The standard of review is de novo. I'm going to be referring to the rules, and therefore I made copies of the rules that I'm referring to that I'd like to give to you and defense counsel for your convenience to save time. May I approach and hand
No,
you?
you can just hold on to them until we're done.
We're done at the end, or? Oh,
Yeah, well, yeah.
okay, because I was hoping that as I'm referring to the rule, you'd be able to look at it with me.
Well, I think because we haven't really had the opportunity for the appellee to review it, it's not, I'm sure that if you reference the rules in your brief, that you should only argue what's in your brief. If you've referenced those rules in your brief, we've already had access to evaluate that, or we will when we look at the record.
Thank you, Your Honor.
Thank you.
It is first important to understand what documents that I wanted to use to impeach Dr. Ali. The first document is titled The Corrected Surgical Pathology Report of Angela Pennington. And at the bottom of this document is Dr. Ali's original pathology diagnosis. Now, that was done on December 1st, 2015. It was read as benign thyroid cells, no cancer. Because of that, Angela Pennington did not receive any treatment. Unfortunately, 3 years later, the cancer that was present in 2015 has spread to multiple lymph nodes in her neck, requiring an extensive lymph node dissection, and also to multiple areas in the lung, requiring radioactive iodine. Now, when she went to University Hospital to receive this treatment, the pathologist, Dr. Waxman, requested the original slides that Dr. Ali looked at. Dr. Waxman looked at the exact same slides that Dr. Ali looked at, and he found the cancer cells under the microscope that Dr. Ali didn't diagnose. Then, this is Dr. Ali's own report. He then corrected his surgical pathology report, put in the diagnosis of papillary thyroid carcinoma. So this is an amended report. Now, Nurse Pennington's sister, Melissa Smith, also had thyroid surgery. Dr. Ali wrote this report where he originally diagnosed the cancer cells as benign. Once again, the slides were sent to University Hospital, and the pathologist found the exact same follicular variant papillary carcinoma that Nurse Pennington had. Angela's mother then had thyroid surgery, and Dr. Ali was the original pathologist who wrote the original report. It was then sent to University Hospital again, and Dr. Ali writes there was a change in the final diagnosis after consult with University Hospital. There is a papillary carcinoma, the exact same carcinoma. Now, I asked Dr. Ali, when a pathologist, a surgeon, a radiologist has their diagnosis changed from a benign cancer to a malignant cancer, that is a memorable event. And when it occurs in 3 family members by the same pathologist, that's a memorable event for the pathologist. I asked Dr. Ali this question in his depo. Quote, have you had any other cases brought to your attention where you reviewed the slides and you did not find a follicular variant papillary carcinoma, but another pathologist did? There was no objection from defense counsel that this is unduly prejudicial. He answered the question, no. I repeated the same question at trial. Have you had
Could I stop you?
Yes.
Because I think there may be some disagreement, because I thought at the deposition he said, no, not that I can remember.
Okay, that's what you were providing. Thank you for bringing it up. I just need one more. Okay. No, not to my, not that I remember of. Page 17 of the deposition. Page 18. So is this the first case that you were aware of? Answer. That I was able to, dash, question, that was brought to your attention? Yes. That I was not able to correct. You know, you can say that. At trial, I asked him the exact same question, and it was a definitive no. And I paused. Okay. And I paused, waiting for an objection. We're going to get into, is this highly prejudicial or not? If this were highly prejudicial, defense counsel would have done two things. In anticipation of me asking the exact same question again at trial, they could have, but did not, file a motion in limine preventing me from getting into this area. At trial, they did not object. How this played out at trial was, he said no, I waited for an objection, I immediately asked for a sidebar. The sidebar was 20 minutes, 61 pages of transcript. The first thing I did is I handed Rule 61-6, method of impeachments, to the trial court judge. I then explained that I had these pathology reports authored by Dr. Lee that I wanted to use to impeach him. And I made it clear, it's only for impeachment purposes. I even asked that a precautionary instruction be given to the jury that this is only for impeachment, not for negligence, and that's on page 56 of the trial transcript. I then made it clear that the sister and mother have not filed any allegations, there's no lawsuit, they're not coming into court to trial, and that there will not be 3 trials in one. This is only being used for impeachment. And what what the trial court said was, quote, page 154, at first blush, it seems to me that we have to look at this as solely impeachment evidence, and that would mean no extrinsic evidence.
Counsel, I hate to interrupt you, but you are at 4 minutes and 40-some seconds of your rebuttal time.
I appreciate the update. Thank you. Okay. So, I wanted to hand this to you, but you'll be able to find it in my brief. Rule 616, staff note, says this. When they're defining extrinsic evidence, in the impeachment context, extrinsic evidence means evidence introduced to the testimony of other witnesses, referencing McCormick. Extrinsic evidence, that is the production of attacking witnesses, is sharply narrowed by the obvious reasons of economy of time and attention. Accordingly, documentary evidence offered through the witness being impeached is not extrinsic evidence because it typically only does not consume much additional time. These pathology reports that Dr. Ali authored are his own reports. This is not extrinsic evidence.
Counsel, I guess I'm a little confused. I want to make sure you are not, did you ever seek to introduce those into evidence or just use them for impeachment purposes?
Use them for impeachment purposes. Okay? Knowing that this should never be introduced into the evidence, that the jury should never get this and take it back to the jury room. Okay? And it's clear. So on page 54, I'm pinpointing where the error of law was made. At first blush, it seems to me that we have to look at this solely as an impeachment evidence, and that would mean no extrinsic evidence would be permitted. During the 20 minutes that we discussed this, that was the thrust of the argument. This is extrinsic evidence, we can't use it. The trial judge also tried to make the argument under 407 that this is a subsequent remedial measure. There's absolutely nothing remedial in these documents. And even if there were something remedial in the documents, the rule specifically says it can be used for impeachment. I would appreciate another update on time before
You
I go.
have about 2 minutes left.
Okay, get right to it. All right. There was only one allusion to unfair prejudice in the trial court transcript. All right? And after that, the trial court says, yeah, but it's extrinsic evidence, so you can't use this. The Ohio Supreme Court in Overland versus Akron defines what is unfair prejudice. It's evidence that arouses the jury's emotional sympathies, evokes a sense of horror, or appeals to the instinct to punish. The evidence must be unfairly prejudicial. Usually, not always, unfairly prejudicial evidence appears to the jury's emotions rather than intellect. Here's the key point from the court. Exclusion on the basis of unfair evidence involves more than a balance of mere prejudice. If unfair prejudice simply meant prejudice, anything adverse to a litigant's case would be excluded under Rule 403. I'm going to, 1 minute left? Or
Yeah, about 45 seconds.
Okay. I'm going to be respectful, and I'm going to stop at this point, and I'll make my final points in my last 5 minutes. Thank you, Your Honor.
Very well.
Good morning. My name is Christine Santoni from the law firm of Perez Morris, here on behalf of appellees, Dr. Fazi Ali and his group, Regional Pathology Associates. I feel like the briefing and the argument may have confounded the issues in this case that are here before the court. This was a medical malpractice case involving an alleged misdiagnosis of thyroid cancer in December of 2015. The cancer was ultimately diagnosed in 2018, and indeed Dr. Ali did amend his original pathology report to indicate that the diagnosis was a follicular thyroid cancer. Throughout the case, and what was at issue in this case, and in fact it was ultimately undisputed, as you'll see in the record, is that although there was a delay in the diagnosis, Dr. Ali's initial diagnosis in December of 2015 did not constitute a deviation from the standard of care, that these misdiagnoses can occur even when everyone is using reasonable and appropriate care, because there is a lot of variability in the diagnosis of this particular type of cancer. That was the nexus of the case. The jury heard a week's worth of evidence and came back with a defense verdict on behalf of appellees. At issue with this case is one particular question that Mr. Misny brought to Dr. Ali during his cross-examination. He has referenced that question, which is at trial transcript page 120, and the particular question he asked, which stems from a prior question he had asked at deposition, was, have you had any other cases brought to your attention where you reviewed the slides and you didn't find the follicular variant of papillary carcinoma, but another pathologist did? As we know, Dr. Ali responded to that question at trial, no. The question was not objected to because the counsel did not think that was an objectionable, and that's not what is at issue before the court today. Before the court today is plaintiff's counsel's request to, and frankly, the impeachment he did do of Dr. Ali in response to that, related to his answer of no to that question, which is cited at trial transcript page 120.
Counsel, maybe I'm a little confused. Let me go back.
Sure.
To something that you had said. You said that you had asked him about whether he had ever had somebody else basically correct his diagnosis, and he said no. If the trial court was refusing to admit or to limit the cross-examination of Dr. Ali in regard to this, I'm just wondering why it would not be objectionable. If it's a matter of, you said the attorney didn't object because frankly it wasn't objectionable. But if it's unduly prejudicial, why wouldn't there have been an objection or a motion in limine to begin with?
Well, it wasn't the initial question that is an issue on appeal. What the issue is when counsel wanted to use two subsequent pathology reports of two different patients to impeach.
But he didn't ask for them to be admitted, it was just for impeachment purposes, right?
Correct, and they had, but what happens is he took Mr. Misny took a sidebar and brought these pathology reports to our attention for the first time at sidebar. And it was the use of those reports that were objectionable, okay? And ultimately, the court, as you've seen, it was a very lengthy sidebar, and I thought Judge Maraldi took a very careful review of what was before him and determined you can use those reports to refresh Dr. Ali's recollection. He allowed plaintiff's counsel to use the reports and then ask him the question again and try to impeach his prior answer. And that's exactly what happened.
Counsel, let me go back.
Mm-hmm.
If the question had been presented to the defendant, have you ever had a situation where another pathologist has corrected a diagnosis of yours? Okay? And he said yes. That would have been okay with the defendant's defense of this matter?
Well, his answer had been in deposition that no, he was not. I mean, he wasn't aware of any of that.
The point is, it's not necessary. I'm trying to figure out why this wasn't objectionable, I guess is what I'm saying. As a defense, I would have wanted that not even to be presented in front of a jury, because what relevance is that?
Well, I suppose you're correct, it doesn't have any relevance, but that seems to be outside the issue that's before the court today. I mean, what's before the court today is the use of these subsequent reports, right? I mean, that's whether and how Judge Maraldi allowed plaintiff's counsel to use them, and he did allow them to be brought to refresh Dr. Ali's recollection, re-ask the question, and frankly, he did impeach him, because now Dr. Ali says, yeah, after looking at those documents, yes, that has happened, and then no further, then it was Judge Maraldi's assessment that no further questioning would be appropriate, because then you're getting into two other potential cases of medical malpractice or potential allegations of negligence that were not at issue in the case before the jury. And as you will see when you look at the discussion, the lengthy sidebar, which goes from of relevance between page 144 to 154, despite Mr. Misny's contention today, the assessment and analysis by Judge Maraldi was that whether the evidence was relevant and whether any prejudicial value or probative value was outweighed, or the probative value was outweighed by any potential prejudice, and that was ultimately what his ruling was based upon, as we see in his judgment entry denying the motion for new trial. So I make sure I'm straight. There was no objection to the question. He answered no, and instead of just proceeding with questioning, which he could have done because there's no objection, counsel conducted a sidebar with the court and alerted everybody to what he was going to do, and that's when the problem came up. Right. Well, had he brought up before the sidebar and said, I want to show you some other pathology reports, I would have objected. To say I wasn't going to object to the admission of the exhibits, which are two subsequent unrelated patients,
Unrelated to this case, but related to the defendant, to the plaintiff.
Well, they were, they were related to, yes, they were relatives of the plaintiff, yes, but they were unrelated to the issue before the jury in the case, which was Angela Pennington's diagnosis in December of 2015. But I don't think if there's some inclination here that there was a waiver of an objection. I mean, he asked for a sidebar, and then we clearly in the record objected to any use of those documents. And then that's what's before the sole issue at issue before the court. And I think the case law that we've set forth in our brief really, establishes the case law and the precedent that using, allegations of other claims of medical malpractice is not, appropriate under these circumstances because it is unfairly prejudicial, and there's a whole body of case law cited in our brief where the courts have refused to allow that type of testimony, which was similar to what was done in this case.
But supposedly the whole point was just for impeachment purposes as a prior inconsistent statement.
Right, and I guess my response to that, he was allowed to impeach Dr. Ali with the reports. I mean, he was given them to refresh the recollection and re-ask the question. That is impeachment. That is, wait a second, you just said no, I believe that answer is not truthful. I'm going to give you an opportunity to look at something, and I'm going to re-ask you the question. And he said yes. I mean, that is impeachment. The question is whether the substance of those reports, then he can be questioned about the substance of the reports, and I think Judge Moraldi rightly concluded that getting into the substance of those reports would be highly prejudicial and was not relevant to the medical negligence issues in front of the jury.
So really what you're arguing is, as I'm getting this, is he was given the right to impeach, so there was no prejudice, he did impeach. And follow-up questions regarding, Dr. Ali, isn't it true in fact that you had 2 other cases where you misdiagnosed? He wasn't allowed to do any of that, and that was not prejudicial.
No, I mean, my position is that any further questioning about that would be prejudicial.
That's what I'm saying.
Yeah, so I mean, I think Judge Moraldi made an assessment of the ability to refresh someone's recollection with the documents and allowed that to happen, allowed the question to be re-asked, but then as it came to the substance of the records, which Mr. Misny has repeatedly agreed that he agrees and concedes should have never gone to the jury, because, I mean, he said that in his brief, he said that here this morning. I mean, the judge agreed with that and said, you're right, that doesn't go to the jury, so I'm not going to allow you to question Dr. Ali further on the substance of the documents, because then we're trying 3 medical malpractice cases instead of 1, and that was the ultimate basis of his decision, as we see in his judgment.
But he did talk about subsequent remedial measures.
Well, I think that is really, it was a comment that was made at a sidebar. I don't think that was the basis of his ruling in this case. I think, you have to contextualize his comment. It was sort of a passing reference to a subsequent remedial measure, but that doesn't square with the trial court's, lengthy discussion on the record and judgment entry denying the motion for new trial, which do not provide a basis that this was a subsequent remedial measure, because if you look at the record, this wasn't a subsequent remedial measure. The only thing that fits is that these 2 cases were subsequent. I mean, there wasn't a remedial measure. But I think
The
this.
trial court did say, for instance, the procedure in review could have changed, the doctor could have changed his procedures, and that would constitute a subsequent remedial measure.
Well, I think what he said is that, he was, in fairness, having been there at the sidebar, it was a dialogue where we're all thinking out loud about this piece of evidence, and he's trying to think it through, but I don't think his assessment and analysis in his ultimate ruling in this case, denying the motion for new trial, came down to an analysis of Rule 407 and subsequent remedial measures.
Just for purposes, when we review the entire record, it'll either be in there or it won't, but what was the testimony in regard to the procedure, this was actually, a pathologist that was reviewing the test results. Is there a subsequent review? Is that the common practice? Because I know, for instance, just as a patient, that if my doctor reviews something, they're gonna send it to an expert. But is there a subsequent review, like two pathologists
Well, I mean,
ordinarily look at something?
in 2015, at the time these were reviewed, they were not by matter of procedure sent to a subsequent reviewer. And that did, I mean, if you read the entire record, was one of the issues in the case, that was addressed by the experts in the case, our experts saying that that was not the standard of care in 2015.
Thank you.
Just the only other issue I want to bring up is that Mr. Misny has argued that this is a de novo standard of review. As we have outlined in our brief, it's our position that this is the standard of review would be an abuse of discretion because it is a ruling on a motion for new trial and also a ruling as to whether to include or exclude evidence at the time of trial. So I think that would set forth a abuse of discretion standard. Thank you for your time.
Very well, thank you. Mr. Misny, I do want to let you know before you begin that you're only going to have about 42 seconds for your rebuttal because you ate into your rebuttal time during your argument. I just wanted to make sure that you were clear about that before we begin. And you may begin when you're ready.
It's time for me to hit the nail on the head. When a judge has shown evidence that a defendant is lying, and we know that Dr. Ali was lying because that judge saw the reports. When a judge has shown evidence that a defendant is lying, the judge must not exclude the evidence that would impeach the defendant who is lying in court. A judge cannot permit a defendant to lie in his or her courtroom.
But the counsel, her reply to that is, he wasn't permitted to lie. You were able to get him to say, yes, I have done that before.
Okay. And my response in 2 sentences is, Dr. Ali was never impeached. If he was impeached, the trial court's opinion would have been, this is a moot motion, he was impeached. Okay? He only was shown, Dr. Ali was only shown that he changed his answer. Changing an answer without any further cross-examination does not prove that the defendant was lying. It only proves that he may have forgotten. Okay, one last sentence. The integrity of the legal system is dependent on judges prohibiting lying in the courtroom.
Counsel, so your argument, as I hear it, is that there's a difference between what happened in this instance and what you argue in your brief about this being sort of an intentional failure to reveal this information. Like you are saying he's hiding it.
I'm saying he is lying in court under oath, and he wasn't prohibited from doing so. The prejudice in that situation is totally against the appellant, and
Okay, I'm going to need you to wrap up.
I'm concluding. Thank you, Your Honor.
Thank you very much. Thank you both for your presentations. The court will take the issue under advisement, and we will issue a decision in due course. On the day that it is released, the court, of course, will mail a copy of the decision to both of you, and will also, you will find it posted on the Ohio Supreme Court website. So thank you both very much for your presentations.
Thank you.